get something on the record?
I did good. It was just in response to Mr. Harvey's last characterization that I was somehow not being totally candid.
I didn't think you were being not candid.
Yeah.
I didn't mean to.
I think he was saying maybe there was something that was suggested was verbatim and it wasn't. The gist of what was said was what I thought you were saying, that, you know, don't get frustrated, he doesn't remember things, you shouldn't ask him about it. But I never viewed that as directed. You may not. It was, you're spinning your wheels if you ask.
And I get that. I get that distinction.
Okay.
I get that distinction. However, the question is not whether or not the detective was directed not to ask these questions. The question becomes, and perhaps it was a very good strategy on the part of Mr. Maples to come in ahead of time and say, hey, like these areas right here, the guy doesn't remember, and you're going to get frustrated and pissed about it. So, you know, I just don't want you to kind of do that. And so it goes all the way back to page 7, where Mr. Maples says repeatedly before the defendant comes in, you know, he doesn't remember where they got off. He doesn't remember where they turned. He even goes so far as saying he doesn't remember the conversations in the vehicle. He says on page 10 that Mr. Harvey referenced, he says, listen, he doesn't remember. So I want to tell you that right now. You're going to be a little disappointed, and I'm just trying to prepare you for the shock. And they say, well, hey, we don't want to hear. And then they say, we just, either you remember something or you don't. And Detective Zimbrick says, yeah, we're just laying the foundation of the whole thing. And that's my point. There's a foundation laid. And does it affect kind of how the interview went? Yes, absolutely. He could have asked whatever he wanted to ask. But, you know, Mr. Maples even says he doesn't know that much about guns to begin with. This is on page 11.
I remember him saying that.
Yeah.
That's not, that surprises everyone now. But here's my thought. You had sitting in the room with Mr. McIver, one of the most, if not the most experienced homicide detective in Metro Atlanta, and a guy who has seen and heard everything. And I don't believe that he was deterred in any way from asking questions that he wanted to ask. More compelling if you're focused on Detective Smith, who's very, very accomplished, but maybe this was a slightly newer rodeo for him. Unless and until this is an issue that the defense makes of the performance of either detective in that setting, I think we're at the right position now. So when we get Detective Smith in here, you ought to pick up wherever you were in terms of talking about the interview, but not with the question, hey, did you handle your questioning of Mr. McIver differently because of things his lawyers said to you? Okay.
Would you indulge me for 1 second?
Sure.
Okay.
You're good?
Yes.
Okay. Let's bring Detective Smith back in, please, and let's bring the jury in.
Jury's all present and accounted for, Your Honor.
Great. Thank you, Deputy Kane. Welcome back, ladies and gentlemen.
May be seated.
We were able to work through the things we usually discuss. Detective Smith is still on the stand, still under oath, still subject to direct examination. You can get rewired up there for us.
I'm trying to.
Great. Manage the feedback.
I hope so.
Mr. Rucker. Yes.
Can you tell the jurors when Mr. McIver entered the room for the interview, what was the first topic area you wanted to discuss with him?
I think most of it is the timeline of events, what happened that day, basically the beginning of your day, bringing it forward, do a timeline on what everybody was doing.
Okay. And can you tell the jury, during that initial conversation about the timeline, did the defendant tell you, or strike that, was he asked questions about any alcohol consumption?
Yes, I believe Detective Zimbrick mentioned that during the interview.
And can you tell the jurors In response to Detective Zimbrick asking questions about that during the interview, what did the defendant tell you about his alcohol consumption that day?
Well, actually, the actual interview is already in evidence.
Well, we had a couple of...
The documents, the video speaks for itself.
Okay, and I guess we could have Mr. Rucker get to that spot in the interview and play it, or he could ask this witness what he recalls the answer to be. How do you want to work that? Or I guess you could present him with a transcript, but I'm going to allow Mr. Rucker to ask some questions along these lines. So
I don't understand. I don't understand the basis other than repetition. In other words, there's nothing at this particular point to be consistent or inconsistent with, because it's the statement.
So it's not ever going to be a hearsay situation, and so consistent or inconsistent to me seems a little less germane. From the time that we saw and heard that statement to now, there has been no small amount of discussion about wine and alcohol consumption, and so I think, I'm not saying by anyone in particular, but topically, that has come up. And so I'm going to allow Mr. Rucker, if he is asking about things, the only time about which we discussed it was just in that interview. I agree with you, and we need to move on. But if it is in connection with things that have come up again and again, I'll allow it. So I now want to best understand the way you'd like it to be presented. The witness's recollection, the transcript, or we get to the spot in the actual video audio and press play.
I think that at least at this particular point, a transcript to refresh recollection would be the most expeditious and perhaps the appropriate way to do that.
Okay.
If you're going to allow it.
I am, and so let's do it that way.
Okay.
That may slow you down a little bit, but I think that's the right way to work through that, especially when you have the support of your
So
team
many
and
great lawyers sitting up here.
She was talking about Ms. Griffin.
Let me have you take a look at this document. Counsel, I'm on page 32.
Thank you.
Yes, sir. And I am on line 12, starting at the question, all the way down to line 17, okay? And the document is being given to you to refresh your recollection. So if you would, you have an objection if he's very accurate by reading that part, counsel, or do you want him to refresh his recollection and then respond to a question?
Well, Mr. Harvey doesn't dictate how it works.
I know it.
No,
Perhaps I should have asked the court. I'm sorry.
Okay.
I'll take it over.
I'm sorry. No.
I don't really think you want to. I just tell you that, but let's just use it as a refresher, given how long ago the interview occurred, and I appreciate that in preparation for his testimony, Detective Smith may well have reviewed things, but if you direct him to an area, just so we know he's particularly refreshed, and then he can answer your questions.
Okay. For the record, have you had a chance to review the transcript?
Yes, I have.
Okay. And so can you tell the jurors when Mr. McIver was asked about his alcohol consumption, what did he say to you during the interview?
He indicated that red wine gives him a headache, and he may only have had a couple of sips of wine that night.
Did you follow up that answer with any specific detailed or probing questions to find out if he had consumed any alcohol, say, while in the vehicle during the ride from the ranch to Longhorn or to Atlanta?
No, I did not.
When you searched the vehicle, can you tell the jury how was the gun positioned with respect to the bag?
Which bag?
I thought you testified that you saw the gun near a bag stuck underneath a purse in the back of the vehicle?
Yes, bag, well, there was a gun in the bag, and then there was a bag on top of the gun.
Okay.
So, which bag do you want?
Well, I'm not really interested in the purse.
Okay,
Okay.
gotcha.
All right. So perhaps you should just describe for the jurors, when you saw the gun, where was it?
It's almost not quite into the rear driver's passenger compartment, their seat. It was almost in the middle of the bench. If you were to put 3 people on a bench seat, it was hard to explain it. If this was the gun pointing this, it was laid this way, and the bag kind of, plastic bag kind of came up to here. You could see the butt, the black butt of the stock of the gun.
Okay. And did you collect that bag as well?
Yes, I did.
Okay. And can you tell the jury, was that also packaged and sent to the crime lab by you?
It was packaged in the bag. I don't believe I took it to the crime lab.
Okay. If it arrived at the crime lab, do you know who requested that it go there?
The district attorney's office.
I know what I'm going to ask you. When the defendant told you that red wine gives him a headache and that he had only had a couple of sips that day, can you tell the jury what explanation did he give you for why he was sitting in the back seat and Danny Joe Carter was driving?
I don't know if there was an explanation. I think I just assumed that I recall that people that were drinking weren't going to drive.
Okay, hold on 1 second. Hold on 1 second. Let me just make sure before I answer the question. It's the bottom of page 31. It should be from here, line 9, down to the end of the page. See if that refreshes your recollection about that question. You can flip over if you need to.
Yes.
Okay, good. All right. So did you talk to the defendant about the positions of the occupants of the vehicle?
I believe so, yes.
Okay. And what position was Danny Joe Carter in?
Driving?
And did the defendant tell you anything about why Danny Joe Carter was driving and he may have been in the back seat?
Except for obvious reasons.
For obvious reasons. Yes?
Yes.
So what were y'all talking about at this point in time?
Alcohol consumption.
Okay. So since he had told you that he was sitting in the back seat and Danny Joe Carter was driving for obvious reasons, but he had only had 2 sips of alcohol, did you ever ask him, hey, why weren't you driving?
No.
During your interview with the defendant, can you tell the jury, did you ever ask him whether or not the gun was inside or outside the bag when it discharged?
No, I did not.
Did you ever ask him to demonstrate for you, say perhaps with a toy or a replica gun, how he was holding the gun at the time that it discharged?
No.
Did you ask him whether his hands were inside or outside of the bag when it fired?
No, I did not.
During the interview, did you ask him or ask Mr. Maples if it was possible if you guys could maybe jump in the car and he could maybe show you the route where the large number of homeless people were?
No. Object to the form of the questions, please. One of the questions was none because it had specific facts.
No, I figured that.
Yes or no? I mean, during the interview, that was something that Mr. McIver told you, correct?
Yes, we had discussed that.
Okay, and what reason did he give you for why he asked for his gun?
It was the area that he was in. He had mentioned he saw a lot of police cars there before and, you know, bad people, I guess.
Okay. That night, did he mention anything to you about seeing a large number of homeless people?
I don't believe it was a large number of homeless people, no.
You don't believe he said that to you?
I don't believe so. I could be mistaken. I mean, it was a long interview.
Okay.
To get a specific
Okay.
page. I know there was talk about people there.
Okay. What did he tell you about the people that were there then?
He didn't feel, from what I understand, he didn't feel comfortable. I don't know what the specific words are, but based on our conversation, he didn't feel comfortable with the people that were there.
Okay. And do you recall him telling you anything about how he felt when he saw these people that were there?
Yes, he did.
What did he tell you?
I don't know his exact words, but
the exact words are out there, and so having someone say, "Yeah, I think it was X," gets into the area of concern that Mr. Harvey appropriately raised. So if you want to refresh his recollection, I'm going to let you continue with it, but otherwise...
I will, Judge.
Okay.
I understand.
Could get complicated.
And in respect, how many times have we met in terms of going over the case in preparation for your testimony here today?
a couple of times.
Okay. And during our meetings, did we give you a chance to kind of review the videotape and audio tape statements?
Yeah, I read them, I've looked at it numerous times, but to be expected to verbatim somebody's conversation, I'm not going to remember every detailed word.
Okay.
I mean, I've looked at them more times than I can remember.
Okay. And this interview lasted about 26 minutes?
That's correct.
Okay. Now, we'll see if we can find those sections in the transcript, okay? During the interview, can you tell the jurors, did you, counsel page 37? Okay. Line 11 and 12.
Gotcha.
Okay.
Yes.
Okay.
Good to go.
So can you tell the jury very specifically, now that your memory's been refreshed, what did Mr. McIver say about the homeless people?
There was a high population of homeless people in that particular area.
Okay. And can you tell the jurors, did he tell you what he said in order to get the gun from, the gun handed to him, I guess is the best question.
He asked his wife to hand him the gun. That was in the console.
Okay. And during your conversation with him, did he indicate that at some point in time, that he was no longer in fear?
Yes, he did.
Okay. And did you ask him, well, why didn't you give the gun back to your wife then?
No, I did not.
Did the defendant, during your interview with him on September the 28th, ever tell you that this large number of homeless people brought to mind for him a Black Lives Matter protest?
No, he did not.
Did he mention that term to you in that interview anywhere?
No.
Can you tell the jury if during the interview, though, did he demonstrate for you or make movements to indicate to you how he was handling the gun at the time that it went off?
He did. I didn't obviously initially see it during the interview because it was kind of partially blocked under the table, but after reviewing the whole interview, yes.
Was it visible to you when looking at the videotape?
Yes, it was.
Okay. Now, did you actually ask him to specifically demonstrate for you?
No, I did not.
So how was it that he came to just demonstrate where his hands were?
It was the line of questionings when I asked him, you know, what happened next, type of timeline of the events.
Let me show you what's minute the state's exhibit. It's number 285A. Do you recognize this?
Yes, I do.
Okay. And can you tell the jury, how do you recognize 285A?
This is our interview room, same interview room we've been in. Mr. McIver sitting in the middle chair between his two attorneys.
And where are his hands positioned?
Looks like just above his...
Stop for a second.
It speaks for itself. I mean, the whole point of having this blow-up is, you know, like, those his hands? Yes. That's what I'm saying.
Okay. Well, I'll take that as a,
Are those his
That's
hands?
yeah, that's an objection.
No, I agree, and I'm sustaining it. The picture's there, you can have them identify the hands in the picture if you want.
yeah, that's fine. Okay. Point out the hands for the jury.
Left hand, right hand.
Okay. And did you determine from the defendant at that time, was he right-handed or left-handed?
I did not.
Did you ask him that question?
No, I didn't.
Did you ask him any questions about his knowledge or familiarity with guns?
We'd asked him if he had any firearms training, weapons training.
And what did he tell you?
He was in the military.
And did he tell you whether or not he had any knowledge with respect to gun safety?
No.
Did you ask him?
I think that was part of the, did you have any safety courses? And he replied no.
Okay. And did you ask him any questions about how many guns he owns or how frequently he fires guns?
I did not.
What did he tell you with respect to the gun that was recovered in the car?
It was his gun. I believe we asked him how long he owned it. I think it varied between 13 and 20 months.
Okay. And did he tell you anything about the frequency on which he uses that gun?
He indicated he hadn't fired it in about 2 years.
That's what he told you.
Yes.
Now, during your pre-meeting, well, strike that. Let me ask you a better question. During your interview with him directly, did you ask him whether or not the gun was in single action or double action at the time that it discharged? Did you ask him that?
No, I didn't believe it was a relevant question.
Why not?
The trigger was pulled. That I'm certain of. Whether it was a single or double action to me, it wouldn't make any difference.
The bullet that was recovered in the front seat of the vehicle, was it collected
Yes.
either by you or in your presence?
Yes,
And that's part of the ballistics evidence that went to the crime lab for testing?
correct.
When you sent it to the lab, did you make any requests for a DNA analysis on the bullet itself to determine whether or not it had actually passed through Mrs. McIver?
No, I'm pretty certain it did. It was in the seat.
You're pretty certain? I don't understand.
I didn't do a DNA test request on the bullet because I was pretty confident that was the bullet that passed through her body.
Okay. Do you know when it passed through her body, how did it end up in the seat? Do you know?
I get asked that questions a lot on cases that I investigate.
Just
Sometimes
a question. Do you know if the bullet passed through her body, how did it end up in the seat? Do you know?
other than it's there, no.
Did you attend the autopsy for Ms. McIver?
No, I did not.
During your interview with the defendant, well, strike that. During your meeting with the lawyers and the defendant, did you learn that the defendant had been admitted to the hospital for anxiety?
Yes, I think with the earlier conversation with Mr. Maples a couple of days prior.
Okay. And can you tell the jury, did you ever get a chance to go over to Emory and speak to those doctors who would have treated him?
No, I did not.
As part of the investigation, did you request his medical records?
I actually obtained a search warrant from DeKalb County, provided it to Emory Hospital, waited an extensive amount of time, called back, they said they lost the paperwork, and to resubmit it, I said we couldn't, a warrant is only valid for 10 days, and I think we had a discussion with the DA's office, they said they would obtain the medical records at that point.
Did you ever get over to the hospital to speak to Dr. Hardy?
Yes, I did.
And did you talk to any of the other doctors and nurses that would have come into contact with the defendant on that evening?
I did not.
Now, after the interview was over with the defendant, can you tell the jurors, were the defense attorneys provided with a copy of the interview?
Yes.
Is that a frequent occurrence?
It's my only first occurrence that I can testify. I've never had an interview with an attorney sitting in the room. So I didn't think it was an issue. Detective Zimbrick was there, and he's been to more of these interviews than I can imagine, and we didn't think that would be a problem.
Okay. And can you tell the jury, after the interview was concluded, did you collect skin cells from the defendant for possible DNA testing?
Yes, we did.
When was that done?
Towards the end of the interview.
Okay.
Well, the interview was over, and then I think we collected
Okay.
right before we left.
Okay. And can you tell the jurors, how was that done?
We have kits, evidence collection kits, specifically for buccal swabs, as they're called. They're provided from us either through the GBI or we special order them. Put some gloves on. There's 2 long Q-tips. Sometimes there might be 4 in the kits. You just swab each side of the mouth with 1 Q-tip, place it in the evidence, swab the other, seal it up, and package it on.
Okay. And can you tell the jury, did you send it out to the lab along with the ballistics evidence?
That was placed into property in case at some point it needed to go down to the GBI.
Okay.
Eventually, I believe it found its way down there.
Okay, what do you mean it found its way down there?
It was taken to the GBI.
Okay, by whom?
I don't recall. I don't believe I did it. I honestly don't remember if I took it down there or not.
Okay. Do you know when it was taken to the GBI?
I do not.
The property section where his swabs, the skin cells would have been placed, is that a refrigerated area?
I can't answer that question for you.
Did you place it in the property?
Yes.
The place where you put the evidence, is that refrigerated?
Where I gave it to our evidence receptionist that is not refrigerated through the window. I'm not sure where they store it from there. I'm sure there's policies about property technicians.
Okay. After the interview was over, were there discussions about returning the vehicle to the defendant?
I think we had talked about it at some point, about getting the vehicle back when we were time frame wise.
Okay. And can you tell the jury, when was the vehicle returned to the defendant?
Our policy is we can't return it once it's towed. It goes back to the tow yard. There's some logistic paperwork, so you have to figure out the tow fees. So I think we released it either that late that afternoon or the following day.
And when the vehicle's returned to him, did you kind of put any restrictions on what he could or could not do with it?
No.
During the course of the investigation, did you consider the vehicle to be a crime scene?
Yes, I did.
After you spoke to the defendant on that Wednesday, what did you do next in the investigation?
I was able to obtain some valet video at the hospital after I got done talking to Dr. Harvey,
Okay.
just for time frame purposes.
Okay. And I neglected to ask you another question about the interview. At the time that you spoke to the defendant there on the 28th, did you ask him for his cell phone?
No, I did not.
Did you ask him any questions about why or why not he may not have called 911?
No, we didn't.
Did you ask him any questions about his familiarity with the downtown Atlanta area?
Not specifically.
Okay. At some point in time, did you receive the cell phone from Ms. McIver?
Yes, I did.
And when did you receive her cell phone? And then once you received it, what did you do?
Can I check to see the time frame on that?
Yes.
Report real quick. I believe it was on October 12th, at around 11:30 in the morning, from Cordy Enterprises.
Okay. Do you recall who specifically gave it to you?
Terry Brown.
Okay. Once you received the cell phone from Terry Brown that belonged to Ms. McIver, what did you do with it?
We provided it to our cybercrimes unit. They have software that will extract the data from that device so that we can look at it.
And did you look at it?
I did.
Did you find any text messages or emails of any significance with respect to the investigation?
I did not.
Can you tell the jury, in your experience, is there an unlimited amount of time under which you can subpoena phone records?
Depends which phone company you're looking for.
Okay.
They all have different, I just took a class on it about a week ago, so there are different restrictions per cell phone company.
Right. And so, how about AT&T?
7 years from what I just learned.
Okay. And within that 7 years, can you get records with respect to text messaging?
AT&T does not store content of text messages. It'll show message to and from, but the content is not provided.
So with respect to looking at Ms. McIver's phone, how were you able to look at text messages?
Once the data is extracted, the software provides a report for us, and you can there's a bunch of tabs you can select, and you can go to messages, and it'll pull them up. And for the most part, they're chronologically, but you can time, date, who it was sent to, content of the message, and just kind of follow along.
You can do that if you have the actual phone. Is that what
You
you're
can
saying?
do that if you have either or. If you have the phone, I think Mr. Brown provided whatever passcode was needed for us. You can look through the phone, or you can look through the extraction report.
Okay. And that could have been done with Mr. McIver's phone?
It could have, yes.
Okay. Can you tell the jury, as part of your investigation, did you subpoena any financial records?
Yes, I did.
And whose financial records did you subpoena?
Both parties, the victim and Mr. McIver.
And did you receive those records?
I did.
Did you review and analyze those records to determine if there was anything of any significance in them to the investigation?
Reviewed them. Analyze would be a strong word for documents. I looked at a bunch of numbers and I didn't really understand them. Money coming in, money going out. That's what I looked at.
And so, does the Atlanta Police Department have a section that kind of, I guess they might like to look at numbers and handle financial investigations?
We have a fraud unit, but I don't think they're on they deal with fraud cases. This is obviously not a fraud issue. So I believe the district attorney's office indicated that they did have a unit of such, then they would be willing to analyze and look at the records to make a determination.
And so can you tell the jury, when during the course of the investigation did you kind of make contact with the district attorney's office to talk about the case?
I don't think it was, it may have been within the first week or the second week. We had an initial meeting with a few members of the DA's office. I think we periodically met over the next couple of months.
Okay. Did you determine whether or not the defendant had a weapons permit?
Yes, I did.
What did you determine?
He does have a valid, or at a time had a valid weapon permit out of Putnam County.
And what does the permit allow him to do?
Carry a concealed weapon. Well, it's not a concealed weapon, it's a Georgia carry permit, which allows you to carry the firearms according to Georgia law.
Okay. And does Georgia law have any requirement about how you store the weapon? Does it have to be in a holster?
Georgia law is whatever Georgia law is.
Okay. If you want him to stay away from this, then I'll sustain the objection.
It's asking for a definition of what the law is.
Well, it's a police officer on the stand who may, if it's established, know something about when police officers can take action or not. But I'm happy to say stay away from it.
If we can establish the foundation for that, are you familiar with that? Do you know the laws? Do you carry? Then that's fine. But
Okay.
just saying, hey, what's the law?
All right. That's a well-founded objection.
Are you familiar with the law?
Yes, most of it. It's confusing. I literally have to read it every time.
Okay, that's okay. I want to ask you. Did you speak to Ken Rickard over at Corey?
Yes, I did.
When you spoke to Mr. Rickard, did you obtain any documents from him?
Yes, I think I met with him on 2 occasions where we provided a bunch of the victim's documents that he thought may be important to the case.
What documents did you receive?
The last will and testament of Miss McIver. I believe we received some various paperwork with written notes and promissory notes due to money, finances, and stuff like that.
Okay. Can you tell the jury what was the amount of the promissory note that you were provided?
I know one was $350,000, and there was an initial one. I don't know if it was a promissory note or just an agreement for $750,000.
And could you determine who owed who the money?
Mr. McIver was the person that received the loan from Mrs. McIver, or the money from Mrs. McIver.
In both instances?
That's what it appeared, yes.
And did you know that at the time that you interviewed the defendant?
No, I did not.
Did you ever execute a warrant for the Atlanta condo?
No, I did not.
Did you ever visit the Atlanta condo?
No, I did not.
Did you ever have the opportunity to interview some of the McIver's neighbors?
I think
Jamie Calhoun or
I did not interview her, no.
Kathy Johansson?
No.
Can you tell the jury, was there some time in October that you would have had a meeting with myself at the DA's office and others wherein we discussed trying to obtain the vehicle back?
Yes.
And can you tell the jury, were you able to obtain the vehicle back?
Yes, I was.
And how did you do that?
I contacted Mr. Maples. He set up an arrangement with James Hugh, and the vehicle was provided back to us, the same place that we processed it on October 7th.
Okay. And can you tell the jurors, was there an order put in place so that the DA's office could retain the vehicle?
Yes, I believe a court order was obtained on the October 28th to hold the vehicle, and we were just storing it for the DA's office.
Okay. And can you tell the jurors, was there a point in time in which investigators from my office actually had the vehicle transported from where the Atlanta Police Department had it stored to another storage facility?
Yes.
And up until that time, who had the keys to the vehicle?
I did.
And then you turned them over to members of the DA's office?
That's correct.
Okay. Now, at the time you received it back, can you tell the jurors who brought it back to you?
James Hugh.
Okay. And did you ask him any questions about whether or not the vehicle had been cleaned prior to bringing it back to you?
I did not, but it had appeared to be.
Go ahead. You know, his
I wasn't meant to.
he was asked a question about what he said. He said, he gave the answer and then went on to another question.
Okay.
Let me object to the answer. Anything beyond the question asked?
All right, let's stay focused to the question asked, and if you need the witness to go further, you can always do that.
Did the vehicle appear to be clean to you?
Yes.
Can you tell the jury, did you travel to Putnam County to the defendant's ranch?
No, I did not.
Did the investigation that you conducted, did you receive any information regarding how much it costs to upkeep the ranch?
Yes. Those are the items.
Okay, yeah. Don't
Yes.
tell me what anybody told you.
Right.
My question is, did you receive information about that?
Yes, I did.
Okay. From whom did you receive that information?
Terry Brown.
Now, can you tell the jury, at some point in time, did you receive information from firearms examiner Zachary Weitzel from the Georgia Bureau of Investigation?
Yes, a report was generated for me.
Okay. And can you tell the jury, once the report was generated, did you come to charge the defendant with any crime?
Yes, we did.
And what crime did you charge the defendant with?
Reckless conduct and involuntary manslaughter on a felony level.
And can you tell the jury, when did that occur?
December 20th,
Of what year?
2016. Sorry.
2016.
And that was approximately how long after the date of the incident?
Almost 3 months to the day.
And can you tell the jury, in reviewing your case file, did you notice perhaps a mistake with respect to that incident?
Sure did, on the last page.
And tell the jury what mistake you noticed.
I noted the month of September when I was going through the report. Crime started in September. It was just an error on my part, chronologically wise.
There was a date you listed in your report for the day in which you charged Mr. McIver.
That's correct.
And in the report, what day did you list?
September 20th, 2016.
But the actual date was what?
December 20th, 2016.
Now, can you tell the jury, at any time before you charged Mr. McIver, did you ever request from Mr. Maples a second interview with the defendant?
No, I did not.
Now, on or about February 2nd, did you have a second meeting with Danny Joe Carter?
Yes, I did.
Can you tell the jurors how that happened and where did it happen?
Mr. Rucker was present, a couple of other DAs. That was the day that we met at our annex where they took possession of the white expedition that was provided back to us. She was asked to join us at that time.
Okay. And while we were there, what did she do?
She sat in the vehicle with myself, Mr. Rucker, and I think another DA. She gave some further information. I think we asked a few more questions, and at that point, once that interview was over, I believe she followed Mr. Rucker and his partners that were there, and they walked over to the vehicle and did a few things there.
Okay. And the few things that we did to the vehicle was what?
I think she sat in the driver's seat. After that, I kind of stepped away a little bit, so I didn't particularly hear the specifics of whatever conversation may have taken place.
Okay. Was it your understanding that we were going over the events of that evening?
Yes.
And so, can you tell the jurors, why didn't you want to participate in that?
I had already done my part of the investigation. I already knew she was the driver of the scene. She provided a statement to us that night. We collected evidence in the vehicle. We know Mr. McIver was handling the weapon. The weapon was discharged. But I didn't have any overwhelming evidence that would convince me or that would show that...
Stop. You need to...
I will.
Now, you
Now,
need to lead a little bit. I will overrule objections as to leading if
Thank
it's
you.
navigating as well.
Yes, sir. Okay. But you didn't participate in Miss Danny Jo Carter, whatever she was doing inside the vehicle while she was sitting in the driver's seat with the DA's office?
Correct.
Okay. Now, during the interview that was conducted with her before we got into the vehicle, can you tell the jury, did she tell you something at that time that she had not told you the first time that you met?
I think there was a conversation of some more talk at the hospital, I believe.
Okay. And can you tell the jury, did you document that interview with Ms. Carter? I'll call it interview 2 with her in any way.
Yes, it was audio. I just happened to have my cell phone and turned the recorder on.
Okay. And can you tell the jury, what did she tell you about what occurred at the hospital that she had not told you the first time that you spoke to her?
I don't remember the exact words of the conversation. If I could have the transcript on that particular, we talked about several things that did occur at the hospital.
Okay. While they're doing that, let me direct you to one other question. Counsel, this is page 38 of the McIver transcript of the interview. Okay. Read this section, please, silently to yourself. You can maybe start up here and kind of get down with this area I've circled as well on focus.
Yes.
Okay. I asked you a question earlier about your conversation with Mr. McIver during your interview with him about his concern about the large number of homeless people causing him to ask his wife for the handgun. You remember that question?
Yes, I do.
And I think I followed that question up by asking you whether or not that concern of his went away, and if so, did he tell you anything about it? And you kind of said, I don't know exactly. But page 38, is your memory refreshed now?
Yes, it is.
Does that page and the words on that particular page deal with that aspect of the interview?
Yes, it does.
Okay, can you tell the jurors what did he say to you about that? His fear or concern about the large homeless people?
Once he was handed the gun, he was, I guess the exact word was relatively satisfied he was out of that area on Piedmont.
So folks with the rest of the papers.
I'm sorry. He said when he was handed the gun,
Right.
he was relatively satisfied they were out of that area.
Okay, out of what area?
I would assume it's the area where he...
Don't assume. It just says out of that area, that's what it says.
Well, that's not quite what it says, but
Okay, well, you're going to refresh your recollection, share with the jury what you recall. If Mr. Harvey wants to explore that recollection, he can. My point was simply, if you don't know, the words are the words, and so Mr. Rucker ought not to ask you to say, what did those words mean?
Well, in the section right before that, did you have conversations with him about the reason why he asked for the gun in the first place?
Yes.
And what was the reason why he said he asked for the gun in the first place?
why have you been asked and answered?
Yeah, we've covered that. Folks can connect the dots.
Okay.
Connect the dots.
Okay. Okay. Counsel, I am on page 2, spilling over to page 3 with respect to the Patricia Carter, what I call interview 2 transcript. Okay, we'll start here on page 2, line 22 through 25 on that page, and then spill over. If you would read that, I'm going to ask you to see if that refreshes your recollection, because I'd like to ask you some questions about what the defendant said specifically. Okay? Not the defendant, I'm sorry, but Ms. Carter said specifically. Okay? Can you tell the jury, what did Ms. Carter say to you in the second interview that she had not said to you in the first?
She had spoke about the initial officers that she spoke to that first responded to the scene and kind of a dislike for one of them. And then as part of that conversation went further.
Did she tell you what the defendant said to her?
Yes.
And what did she say that the defendant said to her?
I'll get exactly the specific, that just tell them that you drove to the emergency room after.
I'm sorry, say it again.
I'm sorry, that you just drove, trying to think the best way to word it.
Just say it exactly like she told you.
That they came down, that she came down as a family friend. Came to the hospital as a family friend.
Can you tell the jury, in your conversation with the defendant during the interview, I asked you about whether or not he told you anything about his familiarity with that area. You remember that question?
Yes.
Now, can you tell the jury, do you recall the defendant mentioning to you anything about the Grady curve during your interview?
No.
Can you tell the jury, when did you turn over your completed case file to the Fulton County DA's office?
So the report was completed on the 29th of December. I think it was turned over a short time after that. It was requested.
Counsel, this is page 40 of the McIver interview. 40? 40. So you can get some context from it.
Yes.
Okay. Can you tell the jury, did you have conversations with him to try to determine what route the vehicle took when it exited the expressway?
Yes.
And can you tell the jury, did he mention something to you about Grady?
He said it skirts around Grady somewhere.
And that was in connection to what part of your interview with him?
I believe it was either the interstate or the ramp, exit ramp. The Edgewood Avenue. It was either the interstate or the exit, the Edgewood Avenue exit ramp.
Thank you, Detective Smith. I think that's all the questions there. Oh, I'm sorry, I do have one more question. The area, what is the area in which you determined the shooting took place?
Based on the video cameras that we tracked the vehicle through Midtown, the last place it was seen was the traffic light on 12th Street. The next traffic light is 14th Street. The following traffic light is, this is all on Piedmont Ave, is the Prado by the Botanical Gardens. And the next traffic light is Monroe Drive. We don't have any video after 12th Street, so I believe it happened somewhere between 14th Street and Monroe Drive.
Okay. And is that location within the city of Atlanta?
Yes, it is.
And is it Fulton County?
Yes.
Thank you.
You're welcome. Mr. Harvey, if you have any questions, you want to say something? Now's the time to start.
It's tough to cover months and months of an investigation in a couple hours, right?
Yes.
And it's clear that your investigation covered a number of months of your work, correct?
Yes, it did.
Okay. And you are a law enforcement officer of some 18 years experience up in Maine, correct?
Combination of both, yes. 5 in Maine, 13 here.
Okay. So a total of 18 years before you became a detective?
No.
Total period?
Total law enforcement, period, from uniform patrol to my current position.
All right. So you've been in law enforcement for 18 years. You've had how many cases? 44 cases as a lead detective?
Yes, I have. Yes.
Correct?
Yes.
And those 44 cases as a lead detective, were those, you're talking about homicide cases?
The majority were homicide cases. A couple of cases were self-defense cases that the homicide department looks into. One was a homicide that was initially a homicide, but eventually during investigation it was discovered it was a suicide. So it's the majority of homicides, but there are other cases in there.
Cases in which someone's death occurred, correct?
Yes.
And you were called upon in your professional capacity to investigate it, correct?
Yes, I was.
You were the lead detective in 44 of those kinds of investigations, correct?
That's correct.
And during that particular time, you've told us a little bit about your training and expertise. You gained valuable experience in working these kinds of cases, correct?
Yes, we did.
You also, during that particular period, often had the opportunity to work with the district attorney's office in those investigations, correct?
Yes,
And we'll get to it a little bit later, but you also worked with the district attorney's office before you concluded this particular investigation, correct?
yes,
Your investigation in this case started the night late, well, early in the morning of the not September 25th, but it would have been September 26th, is that right?
that's correct.
Okay. On September 26th, at 1:20 in the morning was when you first got the call, correct?
Yes, it was.
And at that particular time, September 26th of 2016, perhaps you hadn't done 44 cases. About how many cases had you done at that time?
This would have been my 35th case as lead detective.
Okay. 35 times before you've done these types of investigations, correct?
Yes,
You've had the training to do that, correct?
that's correct.
You've told us about some of the training, including investigative interview techniques, correct?
That's correct.
Did you feel that you were up to the task?
Yes, I did.
Did you feel that you were experienced enough to make determinations about the nature of the investigation,
Yes,
the course of the investigation,
yes,
and decisions about how you were going to continue to accomplish your own investigation, correct?
that is correct.
You've done it a number of times before.
Yes,
Did you have any hesitation in your ability to perform the required tasks in this investigation?
no, I did not.
So you set out to investigate, right?
That is correct.
Okay. And when you set out to investigate, the first thing that you did, as I understand it, you did not go directly to the hospital, right?
That's correct.
You went directly to APD
Yes, I did.
because you understood at that particular time that one of the people, and I'm going to use the term involved, not necessarily meaning the person that was involved, but someone who was at the scene, and in fact you understood to be the driver of the vehicle, was at APD, correct?
That is correct.
You also understood at that particular time that this person, and it's Danny Joe, it's not like it's a secret, right?
Right.
That Danny Joe had been there, was there at APD, correct?
Yes,
That she had ridden R-I-D-D-E-N, with other APD officers to get an idea of the location of where the occurrence, the route, had happened earlier that evening, correct?
yes,
So you already knew that she had talked to APD officers, right?
that's correct.
And you knew that she had taken them to show them a route, correct?
Yes,
You also knew that she had given an interview, which was also audio and video recorded, prior to the time that you arrived, correct?
yes,
So you knew that what she told officers earlier that evening would be preserved as well, correct?
yes, that is correct.
You got a briefing, correct?
Yes,
So you understood at least the parameters of what the investigation was, correct?
yes, I did.
You understood that at that time, without any question, that Danny Joe Carter was the driver of the vehicle, correct?
Yes,
You understood at that particular time that Mr. McIver was in the back seat, rear passenger seat on the right passenger, and that he had discharged the firearm that ultimately led to the demise of his wife, correct?
that is correct.
All right, so there's, as soon as you got into the investigation, there is never any question about Danny Joe Carter was driving, Diane McIver was in the front passenger seat, and Mr. McIver was in back, and criminally or not, responsible for the discharge of the firearm, right?
That is correct.
That was never an issue.
No, it was not.
Okay. And your first step was to interview the person that was there, to say, hey, tell us what happened, correct?
That is correct.
And you know that when you are interviewing and I'm going to say the word precipient witness, that means somebody that was there. Somebody that was physically present and knows what, to the largest extent possible, happened, correct?
Yes.
It's important, is it not, to get to a precipient witness and interview them as soon as possible.
That is correct.
Because everything is fresh in their mind, correct?
Yes.
Presumably.
Presumably, yes.
Presumably. Two, there is less time for any afterthought, correct?
That is correct.
You in your work know that the sooner you get to a witness, the more likely it is that you're going to get an accurate statement of what happened, correct?
That is correct.
That's your experience, isn't it?
Yes.
Okay. So with that in mind, and understanding that that this was a precipient witness, and with the interview technique that you told us about, open-ended questions, right?
Yes.
An open-ended question is the kind of question that Mr. Rucker asked, like, tell us what happened next.
That's correct.
So that you can get the words of the person that you're interviewing in as expansive a form as possible, right?
That is correct.
As opposed to, that was the red car, wasn't it, comma, correct, like I ask questions.
Yes.
Okay. So was your goal and object in that particular interview with Danny Joe Carter to get as broad an expanse of what she could tell you, to frame your investigation and understand what happened that night, right?
Yes, that was the goal.
Okay. And that's the way you conducted that first interview with Ms. Carter, correct?
Yes.
I told you now several times, yes.
Yes. Okay. But you also told her certain things during that first interview. Did you not?
Yes, I did.
Okay. And you've had a chance to review that first interview as well, correct?
Yes.
Because that was provided to you as well for your review prior to your taking the stand, right?
That is correct.
Okay. You know, when you were talking to Ms. Carter, and she told you that they went to Emory, do you remember telling Ms. Carter that, yeah, you know, where you were probably halfway between two hospitals either way?
Yes.
And that you go where, you know, that's where Tex knew. Remember telling her that?
Yes, I did.
Right. So you said, so I wouldn't even try to go anywhere else, because that's where you are familiar with and you would get lost going somewhere else, right?
That's correct.
Okay. You also remember telling Ms. Carter at that particular time that you were going to investigate it investigate everything, correct?
That's correct.
And that's your goal, correct?
Yes,
And that accidents happen, correct?
that is correct.
But we want to go through with the investigation and not look at anything, overlook anything, correct?
That is correct.
And right now, you told Ms. Carter that you had an officer sitting on the car,
Yes,
okay? So that you can investigate the vehicle that Ms. Carter told you the incident happened in, correct?
yes,
You said, we're just trying to figure out what happened, and if it's an accident, it's an accident, correct?
that's correct.
All right. And Ms. Carter said to you, it's a horrible accident in response to your statement, correct?
Yes,
Okay. And you said it sounds like that's what it is.
that is
Right.
correct. Yes,
Okay. You said, well, I haven't seen the vehicle yet because you came straight there to talk with her.
yes,
Okay. And sometimes when you are interviewing somebody, you implore them to tell you everything they know.
yes,
And you want them to tell you everything they know because you warn them, you know, we're going to investigate this, and if we find something else, is there something else out there, you better talk to us now if there's anything else, because we're going to find it, right?
that's correct.
Okay. So when you were talking to Danny Joe that morning, you said, you know, I've got to ask you this. I've got to ask you this. Did you guys, you or Tex or anybody else, ever talk about what somebody was going to say, how it all happened or anything like that, right?
That's correct.
And you wanted to implore her to tell you about any conversation she may have had with Tex or with anybody else about, hey, you can just say this, right?
Yes,
And all she said was, he hated for me, you know, to be drug into this mess, right?
that statement was made, yes.
That's the only thing she told you,
That's correct.
right? She didn't tell you anything about, just tell him you were not here, right?
Right, she never mentioned that.
Okay. That's after you imploring her to do that.
That's correct.
You already knew she was there.
Yes,
She told you she was there.
yes,
She told you Tex McIver was in the back seat with the weapon in his lap, is what she said, correct?
that's correct.
And she said it was a horrible accident.
Yes,
A couple of things at the end of the conversation with Ms. Carter. One of the things that you told us about, or told her about, was what you described as accidental discharge. Remember that?
yes, I did.
Accidental discharge meaning unintentional discharge of a weapon.
That is correct.
Now, I want to distinguish so that we know, accidental, the gun sitting there, it drops, and it goes off by itself. That's not what you were talking about, correct?
No, it's not.
All right. It's not like it gets bumped, it gets knocked, and it goes off without any human intervention.
That's correct.
What you were talking about was the unintentional discharge of a weapon by human intervention without the intention to do so, correct?
That's correct.
and you understand, and you told Danny Joe in that first interview with her, that we have accidental discharge all the time, right?
Yes,
Okay. Where an officer, a trained law enforcement officer, accidentally discharges or unintentionally discharges their weapon, correct?
that is correct.
So that's not an uncommon occurrence, correct?
As far as our police department, no.
Okay, all right. I'm making no commentary on.
Good, you're going to ask your next question.
Okay, good, thank you. You said, I don't know how many we have in the police department itself, correct?
That's correct.
All right. It happens, you said.
Yes,
All right. And you know that it does in fact happen, correct?
that's correct.
You also talked to Ms. Carter, and again, a number of occasions as an investigatory technique, as an interview technique. You make a request, hey, you better tell us everything because we may find something else out later on. You actually do that more than once in the course of an interview, kind of recycling it around to see about if there's anything else, that's been dislodged in the interim by your questions or by the interviewee's responses, correct?
Yes,
You did that with Ms. Carter, and I think, at some point, it just becomes a habit. You recycle that, come on, you gotta tell me everything, because that's the way you routinely perform investigations, correct?
yes,
All right. And one of the things that was in your mind when you were investigating this and taking your first statement from Ms. Carter was, I'm going to go back to the hospital. I'm going to talk to people at the hospital, or there's a possibility that we'll talk to people at the hospital. So you need to tell us what happened at the hospital, right?
that's correct.
Okay. And you also said, usually I go along with what the doctors say, right?
That's correct.
Not so much what the nurses say, right?
Yes,
Because you said to Danny Joe, in my opinion, the nurses are trying to be detectives, right?
that's correct.
So kind of junior detectives out there, you wanted to get it from the doctors, not necessarily the nurses, because the nurses, in your opinion, kind of a hotbed of rumor and innuendo, right?
I don't know if I'd use those words. My wife will get mad at me.
I'm sorry?
My wife will get mad at me.
Well,
She's a nurse. She's a nurse. She's a nurse. She's a nurse.
well, everybody but your wife. But that's what you said.
Right, that's correct.
And I'm not trying to disparage your wife, obviously, but I'm trying to get out what you said. And in talking to Danny Joe, you said, I'm going to go out and talk to the docs. The nurses, they're trying to be detectives.
That's correct.
And finally, in that interview, and finally, in that particular interview, you said, and this is the way you generally try to end your interviews by saying, okay, look, we've talked about whatever we want to talk about here, right?
Yes,
Is there anything else important that I need to know, right?
that's correct.
That's an opportunity, a open-ended opportunity to have that particular person say, well, I didn't say it before, but I may think this is important, or I think this is important, even if you don't, it may be, and I want to tell you everything, correct?
Yes,
All right, and you asked Danny Joe at the end of that interview, is there anything else important that you want to talk about, correct?
That is correct.
And she didn't give you any additional information?
No, she did not.
Okay. You actually told her at that particular time that I want you to tell me now while it's fresh, because I, Detective Smith, in my experience, think that the sooner we get this done, the better the statement is, and that's the kind of statement we rely on, right?
Yes.
Okay. Now that's right away. That's the night. That's the night of the incident. That's the night of the demise, the death of Darren McIver, correct?
That is correct.
All right, and at that point, you're on it. You're on it.
Is that a question?
Yep,
Okay.
aren't you?
Comma, right?
Come on, right?
Yes.
Deep breath.
Yes. But I mean, that's it. You caught the case. It's a homicide case. You've interviewed a precipient witness, and now you're going to take the course that you think is appropriate, correct?
That's correct.
Now, we're at after this interview with Danny Joe Carter, we're at 3 o'clock, 3:30 on the morning of the 26th. You've gotten out of bed, you've come down, you started your investigation. At 4:38 in the morning, at 4:38 that very morning, you had gotten a card of Mr. Maples, correct?
That's correct.
And at 4:38 in the morning, you reached out to try to contact Mr. Maples, correct?
That's correct.
All right. So we weren't leaving any. You didn't say at that point, oh man, you dragged me out. I talked to the main witness. I'm going back. I'm going to catch some Z's, and I will start again in the morning, right?
No, I was continuing with the case based on the information we had.
Okay. You left a message, I guess, for Mr. Maples at 4:38 a.m., correct?
That's correct.
At 4:42 that morning, a search warrant was already signed, right?
Yes.
All right, who got the search warrant?
Detective Klein?
Okay, so you had folks out there, another detective, to prepare, because you got to prepare a search warrant. You got to ask for something specific, correct?
That's correct.
All right, and that is 4 minutes. 4 minutes after you tried to talk with Mr. Maples, correct?
That's correct.
And the search warrant was for what?
To seize the vehicle, take possession of the vehicle that was involved.
Okay, because the vehicle, as you understood it, was the container, I'm going to use that word, container, in which this incident occurred, correct?
That is correct.
So by 4:42 a.m. on the morning of the 26th, you had a search warrant signed, and by 5 o'clock that morning, you arrived at the parking deck at Emory, correct?
Yes.
All right. The search warrant that you got was presented to the valet. You gave it to the valet
Yes.
because you may have had an officer sitting on the vehicle, and when we say sitting on the vehicle, watching the vehicle so nobody could disturb it, correct?
That's correct.
But you also understood that I guess at that point, that it had been given to the valet drove it into park, the valet came back, correct?
That's correct.
All right. And did you understand at that particular time that there had been movement inside the vehicle? Ms. McIver had been removed, put in a wheelchair and brought into Emory. You knew that, correct?
Yes, based on Ms. Carter's statement.
Okay. And you got the keys to the expedition, correct?
That's correct.
Now, did you know that at least part of the APD crime scene unit had already taken pictures of the vehicle, or did they take pictures of the vehicle after you got there?
They had already taken pictures before I got there.
And they took sort of perimeter pictures, they took pictures of the vehicle from the outside, whatever could be visible from the outside, whether they use lights or not or whatever, it doesn't make any difference. They took pictures from the outside, correct?
Yes,
As much as they could, but you wanted to, as any good detective would in investigating this matter, you wanted to get into the inside of it, correct?
that's correct.
All right. In order to do that, you got a search warrant, and the vehicle was towed to be processed, correct?
That's correct.
It was towed to be processed. You had to drive it out of the parking deck because the tow truck couldn't get in.
Yes, that's correct.
All right, well, you know, you didn't move anything.
No, I did not.
All right, you didn't screech around corners so that things would be moved or anything like that. You did it carefully, right?
That's correct.
Like the experienced detective that you are, correct?
Yes,
Now that's at 5 o'clock in the morning. At 7:51 in the morning, you're still working. The vehicle was towed. It was placed in a place that it could be processed. You were on the phone at 7:51 with Mr. Maples, correct?
yes,
And at 7:51 on the phone with Mr. Maples, you were provided the name of one of the attending physicians, correct?
that is correct.
All right, and that was Dr. Hardy, correct?
Yes,
All right. You continued to work that day on this case, correct?
that's correct.
And I understood that at 4:37 that afternoon, 4:30 that afternoon, you got a call.
Yes,
You got a call from Tex McIver.
yes, I did.
You got a call from Tex McIver, not from his lawyer,
From Tex McIver, like you
Yes.
said.
not from his lawyer.
It was from Tex McIver, it was from no one else. Next question.
Well, could have been a conference call. He called you and said, I know I've got to come in and talk to you, right?
That's correct.
And I'm feeling horrible, right?
Yes,
It was a conversation that lasted 1 minute and 50 seconds. He said he was feeling horrible. Did he tell you he had been given medication?
I believe so.
Okay. And that he knew that you wanted to talk to him, correct?
Yes,
And that he was wanting to make arrangements to do that, correct?
that is correct.
And that's pretty much the content of that conversation.
Yes,
On September 27th, was when you were continuing your investigation, and at 9:10 in the morning, is you physically got the search warrant?
yes, I did.
All right, that's when you physically received it, although it had been signed earlier that night.
No, this was a separate search warrant to search the vehicle at our annex.
Okay.
This was a separate second warrant.
Okay, separate second warrant, but for the same thing, to search the expedition now that it was in your custody.
Yes, this warrant was to process the evidence inside the vehicle.
Okay. And to gather specific evidence, correct?
That's correct.
All right. At 9:27 that morning on the 27th, you called Mr. McIver again and left him a message.
Yes, I did.
At 10:55 that morning, that's when you went to process the vehicle, correct?
Yes,
And then to process the vehicle, you went with someone from the crime scene unit, correct?
That's correct.
Someone had taken pictures from the outside before, and now you were going to process the inside, correct?
Yes.
The purpose of the 910 search warrant was to recover the gun that was visible, correct?
Amongst other things, yes.
And to collect any other evidence that might determine the events surrounding the shooting, correct?
Yes, that is correct.
All right. And at 10:55, that's when you arrived to do that processing, correct?
Yes.
While you were waiting for the crime tech to show up, you talked to Mr. Maples again, correct?
That's correct.
And you told him that you were in the process of processing the vehicle as you spoke, correct?
That's
Or
correct.
about to.
Yes.
Or about to. When the crime scene tech arrived, it's kind of a joint operation in determining what it is that you want to either seize or preserve, right?
Yes, I pretty much direct them to collect and photograph what I would like.
Well, in this particular instance, you showed us the diagram that you did.
Yes, that's correct.
And the areas that you were going to focus on, clearly, the gun was, for the record, I was first. The areas you're going to focus on were the gun, right?
That was one of them, yes.
Of course. The gun was visible, correct?
Yes.
You understood that this happened, and we'll get back to it in a few minutes, but this happened somewhere around Piedmont and 14th, in that general area, correct?
That's correct.
So the vehicle had traveled from Piedmont to 14th to Emory, correct?
Yes.
But the weapon was still there in the back seat.
Yes, it was.
It was still visible even from the outside of the vehicle.
Yes.
It was in a bag. It looked like a Publix plastic bag, right?
Yes.
And it was on the back seat near where you understood the shooting occurred, correct?
That is correct.
So that's area number one, and that's where you seized the revolver, correct?
Yes.
Just as obviously was the defect in the back of the passenger seat, correct?
Yes.
Now, you know that there are a number of investigatory techniques that you can use in processing a crime scene, correct?
That's correct.
Sometimes a muzzle to target distance becomes important, correct?
It can, yes.
But in this particular instance, based upon your experience at this particular time, this is one of the things you take into consideration is the spatial constraints of the area in which the incident took place, correct? Spatial.
You mean by the small distance, the
Yes.
small distance inside the car versus outside?
Yes.
That's correct.
While a defect was obviously visible, there was no question that that was a defect and an entrance defect going through the back of the seat. Nobody ever told you otherwise, right?
That's correct.
Nobody ever suggested otherwise, correct?
Correct.
And that there were spatial constraints on the inside of that vehicle, right?
It was a small area, yes.
Yeah, and there is a difference in the spatial type constraints in that area if the doors are closed or if the doors are open, correct?
I'm not sure how that, I'm not sure about,
Okay, well,
I'm confused on the question.
all right, good. Perhaps, obviously, that's my fault. Let me go back. You understood that this occurred while the vehicle was was at a particular location, and you understood that the vehicle was stopped, at least in some form, at a traffic light. That's what Danny Joe told you, right?
That's correct.
Right. So if it's driving down Piedmont and it's stopped at a traffic light, the doors presumably are going to be closed, right?
That's correct.
And in fact, that's what Ms. Carter told you. The doors were closed. There was a bang. There was a plume of smoke inside. And that was when the gun discharged, correct?
That's correct.
All right. So the presumption in the information that you had is that the doors were closed at the time this happened, which further puts some spatial constraints on the area in which you're investigating, right?
Yes, it can.
And those spatial constraints in part informed your decision as to how to proceed at that time, correct?
That's correct.
And it informed your decision because there was no question that Mr. McIver discharged the firearm, correct?
Yes,
There was no question that the firearm was discharged in the back seat, correct?
that's correct.
There was no question that you had the weapon that discharged the projectile that went through the seat, correct?
That's correct.
And you understand that when a firearm is discharged, notwithstanding that it might be in a humongous Publix bag with holes in it, that there'd still be smoke and there'd still be a discharge in that confined space, correct?
That's correct.
So it was your understanding that there would be some gunshot residue everywhere,
That's correct.
or likely to be, correct?
That's correct. There would be a strong concentration in that portion of the vehicle.
And that there, within a certain space between either the back of the seat or the back of where the pocket in the back of the seat was, and the seat would be the spatial constraints.
That's correct.
All right. And as well, side to side, if the doors were closed, that would be an additional spatial constraint, correct?
Yes,
So in making the decision that you did, in the decision that was made that you didn't process for gunshot residue around the defect, was because you thought, okay, here it is, it's right here. There's only a limited amount of space. We don't need to do that.
that's correct.
Okay. And that defect was marked number 2, right?
Yes,
Number 2 with a little sticky on it. That's how you affix the number to the item that you're denominating as number 2, right?
that's correct.
Does the crime tech have any say in that? Does the crime tech say, hey, maybe we ought to preserve this, maybe we ought to see if there's gunshot residue, maybe we ought to put a sticky somewhere else? Or do you say, yo, man, here's what I want you to do, don't do anything else?
That was my decision, as to not check for gunshot residue based on what we saw.
Based upon your professional judgment at the time, correct?
That's correct.
You continued to process the vehicle, correct?
Yes,
And by the way, at that particular time, your physical processing of the vehicle, was there anything about that physical processing or your determination at that particular point that was in any way inconsistent with what you had been told at the time?
No.
There had been a previous agreement with Mr. McIver, Mr. McIver's representatives to meet at 1 o'clock that day, correct?
That's correct.
But that meeting was canceled. And this is the 27th, right? Or is
Yes.
this the 26th?
That's the 27th.
27th. That meeting was canceled, so you didn't meet with Mr. McIver on the 27th, right?
That's correct.
But you received a phone call from Ms. Carter, correct?
Yes, I did.
On the 27th,
Yes.
had I think you described it as maybe a 5 to 10 minute conversation,
I'm
correct?
guessing, yes.
Now, during that particular conversation where she reached out to you on the 27th, did she say, you know, I forgot to tell you yesterday, but you know, Tex told me this and that.
No, that was not during the conversation.
That wasn't part of that conversation either, was it?
No, it was not.
Okay. She also provided you with some other investigative avenues, correct?
Correct.
That you promptly followed up on.
Yes.
Right? You had the phone call with Ms. Carter at 1:17 p.m. At 1:30 that day, you contacted Craig Springer, right?
Yes, I did.
And when you contacted him, it was a direct result of the information you received from Ms. Carter, correct?
That's correct.
And you immediately followed up on it, right?
Yes, I did.
Because you were trying to develop a timeline, right?
That is correct.
Trying to develop as much information as you could about the course of events that evening, correct?
Yes.
And Mr. Stringer, you had understood, had eaten with them at Longhorn and met them at Longhorn, correct?
That's correct.
Indeed, you knew, you also understood that he had played golf with Tex McIver and Diane McIver that day.
Yes.
And all of that went into your investigative, both file and knowledge in this case, correct?
That is correct.
And at 2:20 that day, after talking to Craig Stringer, that's when you looked for the Vic video.
Yes.
All right, you told Mr. Rucker that you knew about Vic, correct?
That's correct.
And that they may have had some surveillance videos, right?
That is correct.
So you weren't sitting on your hands, sitting on your thumbs, sitting around saying, well, I don't know what else to do, right?
That's correct.
Because you knew what to do and you were doing it and you reached out for potential video surveillance, correct?
That is correct.
You also reached out for surveillance from, what is it, Blue?
Midtown Blue.
Midtown Blue, thank you.
Yes.
You can testify anytime.
I can remember what
I
it's
know,
already talked about.
I just, Midtown Blue. Thank you, Your Worship. Right?
Yes.
You know, Mr. Rucker went through these things with you, and he went through these things in detail, but you know what he's saying? He's saying you did a crummy job. That's what he's saying. You didn't investigate it right. So I'm going through these things with you because you did investigate it right, didn't you?
So don't answer that question. If you want to ask a question, then let's do that. That's
Okay,
not an
sure.
appropriate question, but I invite you to continue your thorough and sifting cross-examination.
Thank you. So, getting back to your good investigation,
Object to that, Chief Judge.
So we're going to take our lunch break now, folks. I'd like to keep it as short as will work for you all. 45 minutes has been short, and so if that's sort of the bare minimum we can do, let's keep it at 45. But we're in early today, and it'd be great to get in as much as possible. Should we keep it at 45? Is that sort of humane? Okay, I'm seeing some nods. So let's keep it at 45 minutes, but we'll make it a real 45. Because I know you've been back. We haven't always been able to start up because there have been things we've been working through. So I'll call that 20, what is it? What's that? Clocks. 120. If you all can be ready by 120, that's about 45 minutes, I think. We'll try to get started at 120. While you're taking your break, enjoy time together or apart from each other. Don't talk about the case. And we'll see you at 120. Thank you.
All rise for the jury. You may be seated.
120. That's okay. 120. All right. A couple things for the record. One, in light of the motion in limine in connection with Dr. Sellers, it dawned on me, I had the good luck to work on cases like this one so often, that Rule 615, sequestration here, in this case, is a little more complicated than simply saying, don't come into the courts. And I'm going to ask both sides going forward, and I would have done so at the start of the trial, I just didn't think of it this way because it really hasn't applied to other cases that I've handled in the past, to instruct your potential witnesses, the ones you likely expect to call, to do their best to do what the jurors are doing, which is to stay away from news about the case. The reality is, with the exception of the experts that you all have agreed could be in here, any potential witness could watch what every single witness has to say by watching whatever these crazy feeds are that are out there. And that shouldn't happen because they might as well just come out into court. We might as well not have the rule of sequestration. I'm not suggesting that either side encouraged, asked, or directed their witnesses to do so, but because they didn't say anything to the contrary, no one was violating any direction to have casually or actively followed the course of the trial. So unless you think that that is some improper abridgment of your witnesses' rights, it seems like going forward that should be part of the conversation. You're free to talk to the other side, but it's a problem if you actively follow the case. Dr. Henninger, is he going to testify today or not? Okay. Rule 9.2 says that the notice has to be 30 days. We will be past 30 days when we reconvene. And so there is either an objection and you demand a continuance, or I don't know what, because of course, as we've all figured out, there's not a whole lot of case law on 9.2. So I have to sustain the objection, but the objection then triggers a continuance or a waiver of speedy trial. That doesn't apply here. We don't need to sort through that today. It's food for thought, because when we reconvene, we'll be more than 30 days past the date the state gave you all notice. If you have something you want to say now, that's fine.
Well, there were lots of other reasons, like our right to veto it, even if it gave us 30 days notice. I mean,
Well, veto is different.
well, I understand, but I've made that argument. It sounds like you're not interested in that argument anymore. I'm certainly not going to make it again now. The 9.2 rule says if you give 30 days notice, the defense has the right to say okay or no. We said no.
Well, the way I'm reading it, and you can tell me why I'm reading it the wrong way, is that if you say no, then that means you want a continuance until the witness can be here.
That is not at all the way I read it. I read it that they have to give us 30 days notice, and within 10 days thereafter, we have to respond.
Okay, read it again, and then let's talk some more about it, because...
That was my entire argument. You must have wondered what I was talking about last week when we made the argument.
No. That you can say no, and if it is no, then I have to grant a continuance until that witness is available, and you waive your speedy trial rights.
I will review it. My understanding was, okay, But why don't we just look at it again?
Good.
Maybe I just misinterpreted the rule again. My understanding of the rule was, you can't, if we say we are not willing to waive our confrontation clause rights, then they have to bring a witness, period.
True, but if you're going to insist upon that, that is your request for continuance.
Well,
Until the witness is
So that's what,
but it has nothing to do with 30 days. It has to do until the witness is available. Like Mr. Rucker said, I agree with that. They're going to have to bring the witness if I object, not wait until the 30th day. That's not the problem.
I agree with that, but then I guess you're going to, we'll need to work through the continuance issue, because if that's what the state wants, that may well be what happens. So you should be thinking through whether the least worst option is an indefinite continuance, or that. So you don't need to decide that now. I'm just observing that it won't be untimely notice after we return. That has nothing to do with your ability to say, no, you said no, and I shall sustain that, which means then the only way to go forward is if you say, well, actually, then we withdraw that because we're not interested in a 52-week continuance or whatever.
And it may be. I doubt you're interested in a 52-week continuance. I assume we'd have a mistrial over our objections. But I don't think it's like, okay, well, we'll just continue the case until the woman recovers from her ailment until we'll come back in October. I don't know. I don't know enough about her health situation.
I don't either,
But I'll certainly talk about that.
because that'll be in play. We'll be 30 days out. So it
I'm
wouldn't
not
any...
sure. There's, the 30 days, I'll have to look at that too, because there's rules like with like 10 years, the 10-year rule for impeachment. They say that's from the start of the trial, not from when the witness takes the stand. That's just an obvious when you count. Under 609, it has to be within 10 years. So we'll have to look at the...
I see your point. We will, and I'm
Figure out what the starting point of the last day of the 30 days is, not...
Sure. Would it be when the jury was sworn? Would it be the Monday when we started jury selection? Or is it 30 days from March 2, which was when we were put on notice? So let's work through that. But my point was merely the plot thickens if in fact we're 30 days out, because one objection no longer available is they haven't satisfied the 30 days.
Yes, I agree.
Okay, great, we agree on that then. Finally, don't call me your worship again, okay? Thank you.
Judge, can I put something on the record?
Sure.
Okay. On the record, Judge, in front of the jury, I would like to have the court sustain my objection, particularly to the last couple of comments and really statements made by Mr. Harvey regarding the credibility of this witness. Had I done something like that, listen, we would be arguing about a mistrial. It was really inappropriate. It was improper. He knew exactly what he was doing. And he was at a point where really he was just trying to comment to the jury, really make a closing argument.
About trying, he did.
He did.
Right.
And it was really improper. I want my objection sustained on the record, and I would like you to instruct the jury with respect to those comments by Mr. Harvey. He is one of the best lawyers I know. He's my friend, but it was not appropriate. It was really wrong, especially in this context because there's so many folks watching, and it wasn't right. The other thing I want to say to the court is this. I believe that with Mr. Harvey's questions, he has opened the door to revisit now why it is that Detective Smith did not do what a great detective would have done during his interview of Mr. McIver. In his report on page 12, what Detective Smith says is, Stephen Maples, in this conversation that Mr. Harvey is talking to him about now, well, hey, you talked to Mr. Maples about processing in the car. That's not all they talked about. They canceled the interview on that day. What Maples says is, hey, I could make Claude McIver available, but we could not talk about the actual shooting. That's what he puts in his report. That's why he's been asking those questions. And I think that that is proper for this jury to hear. Particularly now, since Mr. Harvey has spent the better part of his cross-examination and at the very end commenting inappropriately that, hey, this was a great investigation, this is a great detective, and then what the state is doing, they're trying to say you did a crummy job. Well, they ought to know why I say that,
Okay.
if I do.
Got it.
Can I have a brief response, or do you not need it at this point?
No, I think it's good to make a complete record. So let's at least make a record whether I need what you have to say or not.
My comment was directed to the detective, because what the state is doing is they're impeaching the investigation. And I think I have a right to ask the detective about whether or not his investigation was appropriate. That's number one. And number two,
When you say appropriate, though, I mean,
That's not the word you
but yeah, he didn't have a choice to investigate or not. If the wheel comes up, it's his turn. Of course he had to. It's not appropriate or did you mean, was it thorough or?
Yes,
Okay.
yes. I'm not attacking the thoroughness of his investigation, the state is. So the tables are a little bit turned. I'm in an unusual position of saying, I think you did a great investigation. And the state is in the position of saying, no, you didn't. Here are the things you didn't do. And that's precisely what they asked Detective Smith on direct examination. Secondly, I want to go back to the interview itself.
Which,
The interview of Mr. McIver. We've gone through this a bunch, but I want to direct the court to page 12 of that interview and refresh the court's recollection as to the reason the court ruled the way the court ruled when we were at sidebar. The transcript continues to say Cal Leipold, but we know it's Mr. Maples. Mr. Maples says, and so you can talk to him. Detective Zimbrick says, that's fine. Detective Smith, right. Mr. Maples, and he'll answer your questions. I mean, as direct a statement as humanly possible that you can ask him anything and he'll answer your questions.
okay, that's in there. Of course, the full story is more than that, and there were statements made by the attorneys that he's not going to remember this, he's not going to remember that, he don't want you to get frustrated. I don't think that changes my analysis. I continue to agree with the defense interpretation and application of how that would have, could have, more importantly, should have affected what the detectives did. And I see two different issues here. I will say a little something to the jurors when they come back in connection with what Mr. Rucker raised. But at this point, I don't think, although it's not redirect yet, that's a ways away. At this point, I don't think it would be appropriate to ask the detective about things the lawyer said in the however many minutes it was, the 12 minutes that the detectives had with Maples and Michael.
I get it. But at a certain point in time outside the presence of the jury, before we let this witness, before we excuse him, would the court allow me to have, to do a colloquy perhaps for the record of what Steve Maples told him, not at the time of the interview, but prior on the phone?
Sure, we can do that when we come back. We'll get that on the record.
Okay.
And Mr. Harvey, of course, can ask questions about it as well.
Yep.
We'll get that on the record, and that'll be food for thought, depending on how the rest of the cross-examination goes. But for now, we remain where we were, which is stay away from that. Okay? Okay. So, Ms. England, we're off the record now. I need you back here at 125. Okay? 125.